had said. He didn't mention anything about any specific aspect of Mr. Monfort's demeanor. I don't think that that opens the door to the extent that the state now claims that they can argue demeanor as evidence against mental illness, especially now. I mean, I guess this goes to the substance, but you know, the fact that he made a comment to his cousin about liking her decorations has nothing to do with the mental illness in this case. I mean, the court's heard extensive testimony about the diagnoses in this case, including the defense diagnosis, Dr. Cunningham's delusional disorder, and how it's encapsulated. So that comment has nothing to do with his mental illness. It's not evidence of anything. And I think that allowing the state to now argue demeanor is prejudicial, it's contrary to the law, and I'd ask the court not to allow it.
Your Honor, I'd agree. It's contrary to the law until the door has been opened. They can't use it as a sword and a shield. Mr. Gruenhagen made the reference twice, not once. And we can go back to the record if the court has concerns about that, but I have it written down on 2 separate occasions that he made reference to that. And he did so arguing that his outburst or his demeanor in the court is evidence of this obvious mental illness that is a mitigating circumstance.
I'm kind of curious as to what your theory is, that the mentally ill don't have a sense of humor?
No, not at all. His point, though, is that the implication is that listen to how he was, look at how he acted in court. And my response to that is exactly, look how he acted in court.
Well, okay. Certainly the door has been opened to some extent. I will allow the state, if it chooses, to comment on the fact of the defendant speaking out, but not the substance of what he said. All right, anything else before we bring in the jury?
There.
Other than that.
All right, bring in the jury, please. Good morning. Welcome back. Mr. Miller.
Thank you, Your Honor. Good morning. We're here one last time. The state has spent a great deal of time during this part of the trial talking about choices. I talked to you yesterday about a number of factors in Chris Monfort's background: the multiple disrupted attachments, growing up with a depressed mother, being bullied as a kid constantly for many years, and being subjected to racist taunts, racist attacks for much of his childhood. Those factors that I talked about yesterday were not anything Chris Monfort chose. But they did have a great deal to do with how he ended up susceptible to act on extremist or delusional beliefs. They weren't anything Chris signed up for. And you heard testimony in this case directly on those points. Again, from Dr. Brahms, and from Dr. Schouten, the state's expert. Dr. Schouten explained, this is when I was cross-examining him, how the combination of these factors can affect the person into adulthood. He agreed that they contributed to the mental illnesses that he diagnosed in Chris. The personality disorders, he was quite clear that this was not something that Chris signed up for. This is not something that he chose. I asked him the effects, the result of those developmental factors. It's not something that somebody can help, is it? And Dr. Schouten said no, and nobody would volunteer for it. I said, you'd agree that in Mr. Monfort's case, they had a significant influence on his development. Is that fair to say? He said yes. They contributed to his susceptibility to adopting and acting on extreme beliefs. Yes. And Dr. Schouten testified that these influences were completely beyond Chris's control and were in place from the time he was born. He said that's his theory. It wasn't something he chose. Now, the state told you that Chris made a series of terrible and tragic choices in October and November of 2009. And he did. But that fact doesn't help you answer the question of whether there are not sufficient mitigating circumstances to support a life sentence in this case. The question you need to answer. Because every premeditated murder inherently involves choices. Premeditated means thought out ahead of time. You can't commit premeditated murder without making a conscious choice or choices. And the vast majority of premeditated murders don't involve the possibility of life, a sentence of life without the possibility of parole, or the death penalty, because they're not aggravated murders, regardless of how much premeditation is involved. The prosecutor talked about the amount of advanced planning involved in this case, and there was a great deal. But that has nothing to do with the fact of why Chris now faces a presumptive sentence of life and the possibility of the death penalty. There's only one aggravating factor in this case, and that is that the victim, Timothy Brenton, was a police officer performing his official duties. But the fact that Chris made choices is not an additional aggravating factor. You won't find that anywhere in your instructions. It's inherent in premeditated murder. And the fact is that in this case, you heard evidence that there are many circumstances that led Chris, that contributed to Chris making those terrible choices. Circumstances that were foisted on him from birth. Circumstances that, according to the state's own expert, Chris did not choose, did not volunteer for. Circumstances that played a major role in his development and his perceptions of the world. They contributed to his mental illness, whether it was delusional disorder or personality disorders diagnosed by Dr. Schouten. So while Chris did make those terrible choices, choosing to plant the bombs at Charles Street, killing Officer Brenton, trying to kill other officers, and you've convicted him of those crimes, his choices were greatly influenced by forces beyond his control that were in place from birth. I'm not saying he lacked all ability to make other choices. He had that ability. But his ability to choose another course of action was certainly compromised by the developmental factors that we've been talking about yesterday and this morning. Because of his history of mental illness, Chris did not have the same ability to, and the tools, as Dr. Brahms described to you, to make rational choices that most people do. She explained, she said that Chris's developmental level and his background, in addition to his mental illness, affected the choices he ultimately made. She couldn't explain each choice he made. She said, I'm here to explain his developmental background. But there's no question that Chris's mental illness and the developmental factors we've been discussing had a great deal to do with those choices. The fact is that Chris's choices were rooted in his delusions, or at least greatly influenced by his beliefs that were based in mental illness. And those circumstances I've been talking about, the disrupted attachments, the bullying, growing up with a severely depressed mother, the racist attacks, those are all mitigating circumstances that support a life sentence in this case. Now, as I said, there are other mitigating circumstances in addition to those developmental factors. One of them actually kind of relates to those, and that is the fact that there were times during Chris's childhood where he clearly needed help. He needed counseling of some type, he needed assistance, and those needs were ignored. Remember what you heard about Chris's experiences in school, his earliest experiences in school. He struggled, sometimes badly, but there was never anybody to protect him, to take his side. Never anyone who made sure that Chris was in a situation where he could do better, where his problems would be dealt with. Go back to elementary school. Let's remember what we heard about the testimony about Chris's time in elementary school in Hartford City. He started off in the Catholic school. He ended up in the public school. But he was in Catholic school for a couple of years, and he was told to leave. He was kicked out of school. And why? Well, we heard testimony about that from Nancy Lord. Her mother-in-law at the time was on the school board, so she had direct knowledge of this decision by the school to kick Chris out. And her mother-in-law told her that Chris was being told to leave the school because he was causing problems. And Nancy asked, well, what kind of problems are you talking about? Because, I mean, a lot of kids cause problems in school. And then her mother-in-law told her, well, it's because Chris really just doesn't fit in. Because he's biracial. So he got kicked out of school. Got put in public schooling system in Hartford City. And you all know how well that turned out. Then in Bethel, Chris enrolled in the alternative school. And Tony Gross told you about the alternative school. He went there, and for him, that was a better environment than the public schools in Bethel. The public schools in Bethel were bad. But Chris got kicked out of the alternative school, too. And it was Vicki Malone who told you about that. Susan's friend from Bethel. Vicki told you that Chris got kicked out for being too mouthy. It wasn't for anything major. It wasn't for being violent. But he was mouthy. And Vicki herself tried to convince the head teacher to give Chris another chance. And she felt that one way to do that would be to get a psychiatrist to talk to Chris, to talk to his mother, to talk to his stepfather, Dan Fruits, see if they could come up with a plan, see how motivated Chris was to stay in the alternative school. And she got the psychiatrist, Dr. Kautsky, to meet with Chris and meet with Susan and meet with Dan Fruits. And Dr. Kautsky ultimately recommended that Chris should be allowed to stay in the alternative school. He said Chris is highly motivated to stay in school. He'd have been willing to enter a contract, to abide by the school's rules, to conform to the requirements of the administration. But Dr. Kautsky said one other thing that stuck with Vicki and still does years later. You guys saw her testimony. You could see kind of how her demeanor on the stand. She became upset talking about this part. She said it was something that kind of haunted her. Vicki Malone recalled Dr. Kautsky telling her, if some adult would just step up and advocate for this young man, it could make a tremendous difference in his life. And he also said that obviously his mother is too depressed to do something like that. But if you could turn the school around, it'd be a very good thing. Now think about that. After only one meeting with Susan Monfort, this psychiatrist recognized that she was too depressed to advocate for her son and that Chris desperately needed somebody to step up and advocate for him. But Susan simply couldn't. It's not that she didn't want to. It's not that she didn't love and care for Chris. She couldn't. And you heard about that from Rosie Porter, how depressed she was during those times. And ultimately, Vicki Malone couldn't convince the head teacher to let Chris stay. So Chris returned to the public school. And after 2 years there, he returned to Hartford City and attended Blackford County High School. And there he struggled more than ever. He was sent to the school psychologist, Marietta Wolf, for testing to see if he should get counseling or some special education classes. I want to clarify a little bit about Marietta Wolf's testimony, because I think there's been a little confusion. During the prosecutor's cross-examination of Dr. Brahms, some questions came up about what Marietta Wolf said, what her recommendations were, why Chris was sent for testing. So first off, Marietta Wolf testified that Chris was referred to her for testing because he was underachieving in some classes, particularly English class. There was a disparity between his aptitude and his performance that suggested that the school wasn't doing its job. He wasn't learning adequately. But in administering the tests, other things came up. It wasn't just his educational performance. Marietta Wolf noticed that Chris exhibited an extreme level of anxiety like she had never seen before. His hands shook. His breathing was labored. His anxiety was evident just in his physical demeanor. He made comments to the effects that, I bet you think I'm dumb. People who take a really long time on these tests probably are really dumb, aren't they? Ms. Wolf administered those tests to about 2,000 students over the years, and as I said yesterday, she'd never seen anybody with his anxiety level. So what's going on here, what was going on back in 1983 in Blackford County High School, was that, yeah, Chris was not initially referred for a psychological evaluation, but it quickly became apparent to the psychologist that he had significant emotional and psychological problems. Ms. Wolf testified that Chris's performance on a number of the tests suggested emotional problems, significant emotional problems. She tested unequivocally that she believed Chris needed counseling for emotional disturbances. That was her opinion. Now, that was the recommendation she felt was important. Now, the report referred to by the state is less clear on the need for counseling because first off, it was made by a committee of 6 or 7 people. So Marietta Wolf made clear she thought he needed counseling. The report said he might benefit from counseling. And Ms. Wolf said, yeah, the wording on that's ambiguous, and she explained why. They never assumed counseling's going to help, so they worded it as might benefit. And there were bureaucratic reasons involved. If they recommended him for classes for the emotionally handicapped, the school would have been liable for that expense. So there's a liability, cost consideration that was part of the reason that the recommendation said he might benefit from counseling. But Marietta Wolf was clear. In her opinion, Chris needed counseling for emotional disturbances. And she recommended to Susan that Chris get into counseling to figure out why he was underachieving, why he had such high levels of anxiety at age 14. And again, he never got the help that that people clearly recognized Chris needed. Childhood is where the damage gets done. Another mitigating factor is this kind of is self-evident. I'm not going to spend a long time on it. Life in prison is going to be especially severe in the case for Christopher Monfort. I think it goes without saying that a sentence of life in prison with no possibility of release or parole, in any case for any person, is an extremely harsh sentence. It's the second harshest recognized by Washington law. In many states and most countries in the world, it is the harshest sentence recognized by law. But in Chris Monfort's case, a life sentence is going to be particularly hard for obvious reasons. And you heard some of those from Dr. Cunningham. Chris is paralyzed. He's confined to a wheelchair for the rest of his life. And his paralysis includes the side of his face, which affects how he talks and how he looks. So the prosecutor referenced him sneering at one point yesterday during an interview with Dr. Schouten. And Chris doesn't have normal facial expressions. He does have numerous medical issues, infections, chronic pain, that will always make his existence in prison more difficult than the lives of almost any other prison inmates. You heard that described by Dr. Hall and Jim Illica, both of whom testified in this case. You know, I don't know if any of you have ever visited a prison in your lives, but if you have, you may have gotten a glimpse of how bleak life inside those walls can be. And now imagine how it's going to be for Chris Monfort. Which really makes the prosecutor's statement, their argument that it's just changing residences, just that much more galling. Despite what some people may believe, life behind bars is no picnic for anybody, especially if there's no chance of getting out. It's going to be far worse from Chris. It will be a sentence. It will be a severe punishment consistent with the crimes he's committed. And Chris has made a good adjustment to incarceration. You heard from the officers, you heard from Jim Illica, you heard from Dr. Cunningham. He seems to get along well with the jail guards, the corrections officers. He has had, I think the testimony was 5 infractions. A couple of them had multiple charges. They're all fairly minor. There was one where he knocked on the wall of his cell with his arm from his wheelchair. But for the most part, he's made adjustments, and they were difficult adjustments. Jim Illica told you about some of the adjustments he had to make as far as getting used to being incarcerated, adjusting to his loss of freedom, his injuries, his paralysis, his pain levels. It's an ongoing process. But he's adjusted well, and as Mr. Gruenhagen explained, there is no evidence that Chris is a danger to harm anybody if he is sentenced to life in prison. Another mitigating circumstance, and this really dovetails with the mental illness that you've heard about, is that Chris, as psychotic as this is, Chris Monfort believed what he did was right. every expert you heard testify in this case, including Dr. Schouten, stated unequivocally, he believed he had a duty to do what he did, to stop police brutality by going to war against it. And to be clear, in his mind, Chris was at war against police brutality. He was not at war against the city of Seattle. The evidence in this case is, there's plenty of evidence in this case, including the testimony of the experts, but also the evidence at Charles Street. Chris didn't set out to harm civilian employees. He wasn't out to harm any property that didn't belong to the Seattle Police Department. Now, part of what the state argued during the last phase of trial is that police brutality is actually a very real and pervasive problem in society. People are more aware of it now than they were back in 2009. Therefore, Chris wasn't mentally ill. His beliefs weren't idiosyncratic. And I agree with that. It has received more attention in the years since Chris was arrested. That's one of the reasons they said he wasn't delusional. But Chris's beliefs about how to stop police brutality and his unique role in doing so were rooted in mental illness. And none of the experts in this case who testified disagreed with that. The notion that he had to kill random officers to stop the brutality, that's just crazy. But he did believe it. He believed it to be true, and he believed it was a necessary duty of citizenship. Now, the state apparently now disputes what all the experts in this case testified to. The prosecutor referred repeatedly to Chris's actions as selfish. Well, that quite frankly is simply an effort to dehumanize Chris and to convince you that he should be put to death. But ask yourselves, did you hear any of the expert psychiatrists or psychologists in this case describe Chris's thought process as it relates to his crimes as selfish? They didn't. Not even the state's own expert witness. They all agreed that Chris had a personal duty, believed he had a personal duty to stop police brutality in order to protect the community and his fellow citizens. Acting selfishly, as the state claims, implies he was motivated by some personal gain. There was no personal gain for Chris Monfort. He wasn't seeking revenge for something the police did to him personally. He wasn't seeking fame or attention. He wasn't trying to advance himself up the food chain in some radical organization. There was no personal gain. Chris committed a terrible and violent crime. There is no question about that. But he was not motivated by personal gain. This was not an act of selfishness, as the state claims. You've heard no evidence to support that. What you heard was testimony from every expert who evaluated Chris that he genuinely believed he was acting out of a sense of duty to protect his fellow citizens and the community from police brutality, and that belief was grounded in mental illness, regardless of the diagnosis. And there were different diagnoses. The prosecutor also told you that Chris rained terror down on the city of Seattle and that he wanted to inflict as much damage on the police department as he could. And that's another attempt here to dehumanize Chris, and it's also at odds with what you heard from the experts in this case, including Dr. Schouten. They told you Chris was targeting police, and only police. He wasn't trying to terrorize the community. In his mind, clouded by mental illness, he thought he was protecting the community. And he wasn't out to inflict as much damage on the police department as he could. He was trying to compel the police to reform their own conduct, to stop brutalizing citizens. That was his mindset. I know that that's diluted, but that was his mindset. That was Chris's beliefs. And you heard testimony on how he thought he had to do that. He needed to reach that tipping point, the magic number you heard so much about. So, the prosecutor's hyperbole, their attempts to dehumanize Chris by making claims that are unsupported by their own expert, don't buy those. That's not consistent with what you heard. Diluted as it was, Chris believed his actions were right. And that's absolutely crazy. But it is mitigation. Chris has family members and friends who still love and care for him. And they would suffer greatly if Chris is executed. Over the course of this trial, you've heard from dozens of people who have known Chris at various points in his life. 2 days ago now, you heard from Christine Schillinger, who told you about how traumatic it would be for her whole family, including Susan Monfort, if Chris is sentenced to die. Now, Some of you probably thinking, well, Chris didn't think about Tim Brenton's family and friends when he decided to go out and kill a police officer. And he didn't. Because as Dr. Brahms explained, his mental illness prevented him from going there, from even thinking about the fact that the officer he was shooting might have a family. Because in Chris's mind, he was a soldier at war. The prosecutor spent a fair bit of time arguing yesterday that Chris lacked remorse about how he told Dr. Brahms in July, "What good does it do to think of him as a person? I won't cry for the enemy or their kids." But that ignores most of what Dr. Brahms testified to on the issue of remorse and Chris's feelings of sympathy. She said that he feels that what he did was legally correct and morally correct. And we know that. We've heard testimony for weeks, months about that. But she also said he feels tremendous sympathy about the damage that's occurred. And that's where the dichotomy is. That's where the dichotomy comes in. That's where the mental illness is. And she explained that Chris's statements about not wanting to think about the victims in this case, she said it would hurt too much. He doesn't want to talk about his actions because it causes him emotional pain. The point Dr. Brahms is making, and that the prosecutor ignores, is that Chris's inability to say that he's sorry for his actions is rooted entirely in his mental illness. Dr. Brahms told you that for Chris, sympathy is his ability to express sadness and regret and responsibility for what he did. He takes responsibility for what he did. He regrets, he has sadness, he understands the implications of what he did. He has not said directly, "I'm sorry," because he is still involved in his delusional system of being a soldier and doing what he needed to do. The state also ignored Dr. Brahms' testimony about her meeting with Chris just last Sunday, where he told her he now recognized that he caused tremendous pain to Officer Brenton's family and others who knew him. He does have compassion and sympathy for Officer Brenton's survivors. It's filtered through the lens of mental illness. He still believes what he did was necessary. Now, and every expert you heard from agreed that he believed it was necessary because of mental illness. You members of the jury are not making your decision in this case through a distorted lens of mental illness, unlike Chris Monfort. You are able to consider and really think about the suffering a death sentence would bring to many people, many of the people you heard from and heard testify in this case. Chris's family members, his friends, his mother. These people, every one of them that testified, told you they can't understand what he did. They were angry, upset, distraught about what he did. They don't get it. But they still love him. And that's another reason for a life sentence in this case. The last mitigating factor I want to talk about is that Chris has been a positive influence on people throughout his life. And he has shown consideration for others, kindness towards others. And that's just not as a kid. That's up to the time that he was arrested in this case. Many of these, some of these that you heard about, you may have wondered, well, why are we hearing about that? These are pretty small things. These are minor. But I think they paint the whole picture. You heard from video testimony from Elia Long. Elia Long was the guy that worked in the music store. Chris was a customer there, played guitar, got his guitar tuned. They had casual conversation. They weren't friends. They didn't know each other well. Along the way, Elia Long had mentioned to Chris, kind of in casual conversation, that he had celiac disease. He's extremely gluten intolerant. And then Christmas time comes, and people are bringing cookies and baked goods into the music store for people, for the employees. And Elia Long can't eat those. They make him extremely sick. One day, Chris shows up with a fruit basket. He says, "Hey, man, you can eat this stuff, right?" And Elia Long told you, people that were like close to him, good friends, didn't think to do anything like that. Chris Monfort, somebody he didn't know very well, just knew from being in the music store, he did think to do that. And Elia Long described that as a very considerate, compassionate act. Chris's aunt, Cam Martin, told you about how when she was diagnosed with MS, Chris brought her some tapes that he thought would be helpful, kind of help her get through that. Will Buchema, in the first phase of trial, told you about how Chris showed up one day with $20 because he knew Will was down on his luck. He said, "Here, take your girlfriend out for dinner. Kendall Bull told you about how he gave him, I think it was $100 to buy presents for his kid. I mean, you know, these are small, but they paint the picture. There are a couple other witnesses that I think were more significant, that Chris had a much bigger impact on their lives that you heard from. The first is Tony Gross. Tony Gross described Chris to him as a hero. We already talked about the bullying. I won't repeat that. The fact that Chris was the one person in those years at Bethel who ever stood up for Tony Gross, who tried to stop him from getting beaten up, who tried to stop the bullies. But he also tried to help Tony Gross in another way, deal with this problem. He said, you know, you don't have to fight. If you can, it's okay to run. You don't have to stand there and fight. If you can get away, it's okay to run. And Tony remembered that 30 years later. More than 30 years, he still has vivid memories of Chris Monfort, still regards him as a close friend, and remembers how Chris stood up for him and helped him when nobody else would. And then there was Megan Hanning Bean. I'm sure you all remember Megan. Very impressive young woman. She wants to devote her life to helping people. She has applied to join the Peace Corps. Now, Megan didn't get that way in a vacuum. Like most people, most young people, Megan needed adult support and influence and guidance in her life. And she told you. And it can't have been easy for her to tell you. She didn't get that kind of support from her father. They lived in the same house, but he was largely absent. He didn't show up at her sporting events. He didn't teach her how to throw a ball. He didn't play music with her. Megan got that support from Chris Monfort, the man she knows as Uncle Chris. Chris Monfort told Megan she could do whatever she wanted. She could succeed. She was awesome. They played music together. They were going to make a music video together. He took her out and played catch, taught her how to throw a ball. Turned out she was pretty athletic. Her parents never went to any of her soccer games. Her Uncle Chris did. When he showed up to town, he'd go to her soccer games. Chris Monfort was the adult who gave Megan the confidence and self-esteem and inspired her to help people. And she got up on the stand and told you that, as difficult as it was. You know, she is an incredible young woman. She's a young woman she is today, in part because of the influence of Chris Monfort. So, you know, is the man that helped Megan become this incredible young woman so devoid of humanity that the only just punishment in this case is to sentence him to die? No. No. The prosecutor acknowledges many of these factors. They say, yeah, you know, there's mitigating factors in this case. We concede that. You know, he has no criminal history. There's mental illness there. His background was probably pretty rough. They may dispute some of them. They may dispute the extent to which his childhood and upbringing are bad. I mean, you know, you're going to have to decide that for yourselves. But the question you ultimately need to answer is, has the state met its heavy burden in this case? And if so, how have they met that burden? And it's not by simply repeating the word choices. They told you in opening that they could only present one witness in this case. And quite frankly, that's really only partially true, and it's misleading. They were limited to one witness who could describe the impact of the crime on the victims. But the state could have presented as many rebuttal witnesses as they wanted. Just like in the guilt-innocence phase. Once we sat down, once we rested, they had the opportunity to present rebuttal witnesses. And they did. When we rested a couple days ago, Mr. Castleton stood up and he said, the state has no rebuttal. They didn't present it. The one thing the prosecutor hasn't addressed, and they may when they get back up here, but they haven't so far, is what would be sufficient mitigation. What mitigation would be sufficient in their view to support a life sentence? Their position here is that, well, there's mitigation, but there's not enough to merit leniency. What would be enough? Anything? If Chris Monfort were more mentally ill, you know, if that were the case, he'd have been insane. He wouldn't be discussing his sentence. Maybe if the bullying, the abandonment, the racism, the other aspects of his upbringing were even worse than they were, Would that be enough? I've asked the question. I anticipate that they will at least try to answer it. But the fact is they haven't offered you any suggestions so far, because their real argument comes down to this. This crime should always result in the death penalty. And to its essence, that's their argument. And that's simply not true. The judge's instructions tell you that the state has the burden. Chris Monfort is presumed to merit a life sentence. That's the presumptive sentence in this case. They have to disprove that beyond a reasonable doubt. Now, they will get up here and tell you, we prove the evidence of the case. We prove the evidence of the crime. But that doesn't overcome the presumption that Chris should be sentenced to life without parole. They also presented the officer presented Matt Brenton. And members of the jury, there is no question that Matt Brenton and the entire Brenton family have suffered tremendously over the loss of Tim Brenton. And I can't imagine how difficult that is. But the judge's instruction number 7, tells you that this testimony can be considered for the purpose of describing the effect of the crime on Officer Brenton's family, and that you cannot consider it to determine that the death penalty is appropriate solely because he was a reputable member of the community. And as I said, if they had evidence to rebut the mitigation that we presented, they weren't limited to just calling Matt Brenton. They could have called as many rebuttal witnesses as they wanted. They chose not to. So the prosecutor does get up here and argue in rebuttal, and in all likelihood, as I say, they'll tell you that they've proven the facts of the crime. That's all they need to do. They've met their burden. It'd be their argument. But that ignores the law. It ignores the fact that the law requires you to presume a life sentence. In the end, the state in this case, in this part of the case, had the heaviest burden recognized by law, the burden of proof beyond a reasonable doubt, and they have failed to overcome that burden. They haven't met it. Their attempts to prove that have failed. Prosecutors started off back in their opening statement in this phase, and again yesterday, by quoting Eleanor Roosevelt. Eleanor Roosevelt was a wise woman. She was ahead of her time. So I'd like to share with you another one of Eleanor Roosevelt's quotes. It was in a column she wrote back in 1960. She wrote, "It's not the physical part of man which is so important. It is that spark in him which raises him above the animals. Has any other human being the right to take that away in the name of justice? Our knowledge of human beings is limited. We cannot know all about any other human being. For the protection of society, if a human being seems dangerous, we have a right to limit his contacts and thus protect others from the danger. But I doubt if we have the right to take away a gift which we alone cannot give." She was talking about the death penalty. Eleanor Roosevelt was against it. But the laws of Washington State do give you, as members of this jury, the power to take the gift of life away from Chris Monfort. I don't know about you guys, but that to me seems like an awesome and terrifying power. And it should be exercised only in cases where a person has not only committed a terrible crime, but where that person has no shred of humanity remaining in them that is worth preserving. And members of the jury, Chris Monfort is not that person. I know it's time for me to finish here. And as much as I'm ready and I want to shut up and sit down, and as much as I know that you want me to do that too, I'm afraid to do that just yet, because I've never had to stand up in front of 15 strangers before in my life and ask them to spare somebody's life. And I keep thinking, maybe there's something I'm forgetting. Something that might make a difference to one of you and convince you not to kill Chris Monfort. Because this is the last time I get to talk to you. The prosecutor gets to stand up here again once I sit down and try once more to convince you that Chris needs to be put to death. And we don't get to say another word. So I am going to finish here. But before I do, I want to ask each of you to do a few things. One, respect the opinions of your fellow jurors. There is no formula, there's no precise mathematical equation that can give you an answer to the question you need to answer. Some of you may find mitigating, others may not, and that's okay. Each of you need to vote your own conscience in this part of the trial. Each of you need to decide independently for yourselves whether the correct sentence is life or death, whether the state has met its heavy burden in this case. And the second thing I'm asking you to do is to read and follow the court's instructions carefully. Think about what it means to hold the state to its burden of proving beyond a reasonable doubt that there are no sufficient mitigating circumstances that support a life sentence in this case. You have heard evidence of many mitigating circumstances that support a life sentence in this case. So hold the state to its burden. And always keep in mind that the law presumes a life sentence. And 3, I want you to consider all the testimony and evidence you've heard in this case and think about whether it adds up to mitigation sufficient to support a life sentence. Consider all of the mitigating circumstances we've talked about in the last couple of days. The ones specified in the court instructions that Mr. Gruenhagen talked about, and the ones I've been talking about yesterday and today. You know, I think if you take all that into consideration, if you apply the law, you'll realize, you'll agree, that justice in this case does not require that you sentence Chris Monfort to die. Justice in this case does not require that you sentence Tony Gross's childhood friend to die, that you sentence Inez Williams' nephew to die, that you sentence Janice Brahm's cousin to die. It does not require that. Justice in this case does not require you to sentence Megan Henning Bean's Uncle Chris to die. It does not require you to sentence Susan Monfort's son to die. Justice in this case, for this man, is best served by a sentence of life in prison without the possibility of release or parole. The same law that I talked about a minute ago, the law that gives you the power to take the gift of life away from Chris Monfort, also gives you the power to punish him severely while preserving that spark that Eleanor Roosevelt spoke of, that gift of life, by sentencing him to life in prison without the possibility of ever being released. Members of the jury, please choose life.
Because the state has the burden, the state is entitled to rebuttal argument. Please give your kind attention once again to Mr. Cassidy.
Good morning, ladies and gentlemen. You'll be happy to know we will be done before the break. I wanted just to address a few of the issues raised by Mr. Lohr, Mr. Gruenhagen, Ms. MacDonald, and unfortunately, I'm just going to refer to defense counsel as opposed to each of their arguments as all three of them got up here. But I wanted to point out a couple of the arguments that were made about the burden of proof here. Because counsel's absolutely right. The defense has no burden here. They did not have to put on a single witness. They did not have to do anything in this phase. And yet, they called 32 witnesses. Now ask yourself, why is that? The presumption is life. And that is the presumption. As you sit here today, the presumption for Mr. Monfort is life. It's not until you go into the jury room and deliberate and make your decision do you actually talk about and think, has the state overcome that burden? So why did they put on 32 witnesses? Because they know, as they have said numerous times, they have conceded over and over again how horrific this crime was. Mr. Lohr says to you, the state's argument is, well, anytime someone's convicted of this crime, they deserve the death penalty. Well, that's not true. Remember what we talked about, the various aspects and the types of crimes that can occur when a police officer is killed. There are all sorts of situations where a police officer on duty can be killed. Maybe all of those deserve the death penalty in some people's eyes, But look at the facts of this case. Not the crime, but the facts of this case. This was an assassination. Mr. Gruenhagen had an issue with that word, but there's no other term that describes it better than that. This was an ambush, and this is what Mr. Monfort wanted and chose to do. And yes, he did choose. It was not because of his mother's depression that he chose this. It was not because he was bullied that he chose this. It was because he was fed up. As he told the experts, he was fed up with the police brutality, and he chose to do something about it. It wasn't in 1991 when it first came to his mind when he saw the Rodney King incident, which he said that's when it first kind of came into my mind. It wasn't when he decided to go to Highline and become interested in criminal justice, when Gary Wegner, who for all intents and purposes was his mentor there. It wasn't when he went to the University of Washington and became a law, society, and justice major, where he learned more and more about this. He saw videos of police brutality. He saw the horrible Oscar Grant video, the Malika Calhoun video, and all others. And you know what? He just got fed up. It wasn't when Rodney King happened that all of a sudden his entire childhood came back to him, his upbringing, and he said, that's when I'm going to do something. No. It was 18 years later. So, ladies and gentlemen, with regard to the burden here, the defense has no burden. But ask yourself, why did they call as witnesses? And we know why. It's to show that there is mitigation. And again, there is mitigation. The question is whether it is sufficient. That is the question. The crime here was horrific. And no matter how many times defense counsel says it to you, Ms. McDonald said it, Mr. Gruenhagen said it, and Mr. Lohr said it, we acknowledge this is horrific. This is a terrible crime. It doesn't make it any less horrific because defense concedes it. It is horrific. It was egregious. It was cold and calculated, and their concession doesn't mean you no longer consider it. That is the reason this crime, these facts, demand a punishment of death. Mr. Gruenhagen talked about, again, the horrific nature of the crime, and in his own words said, this was the worst of all possible things. I agree. I believe it was Mr. Gruenhagen who also said that when I got up here, my goal was to try to convince you that Mr. Monfort was a psychopath. And if that is how Mr. Gruenhagen took it, and if that's how any of you took it, I certainly did not mean that. Because that is the last thing I would try to prove to you in this case. Because as we all know from the testimony of Drs. Schouten and Dr. Cunningham, a psychopath cannot feel empathy. He does not understand and feel the pain of others. Mr. Monfort absolutely does. And in this case, he just chose not to care about it. You heard the testimony from Dr. Brahms, about what he told her. And I'm not going to repeat it. Mr. Lohr stated it. I stated it in my initial closing. He didn't care. He does have capacity to feel. He does have capacity to care. But he didn't care about Tim Brenton. He didn't care about Britt Sweeney. He didn't care about Gary Nelson. He didn't care about any of the police officers that he killed and chose to try to kill. So Mr. Gruenhagen is wrong. I'm not trying to convince you he's a psychopath. At least a psychopath would have some sort of excuse. Mr. Lohr talked to you about Mr. Monfort's move from the King County Jail to the Department of Corrections, and said it was, I believe, the most ludicrous or egregious, or I can't remember what the word was, but it was the worst thing he's heard, argument he's had. Well, let's talk about the evidence in the case about actually what's going to happen to Mr. Monfort, because there's not a lot. But let's talk about what we actually learned in this case. We learned in this case Mr. Monfort's current condition is pretty bad. And when I talk about his condition, I talk about his living condition. Because of his ultra-security status, he's isolated. But because of his injuries, that again are solely his responsibility, and because of his actions, he has to be housed in the infirmary. And you heard testimony from both Mr. Illica and Dr. Hall that the King County Jail is not equipped to house someone for 5.5 years with those two different conditions, the ultra-security and the medical condition. And yeah, his situation was bad, and it is bad. He was in isolation. The only time the therapist could talk to him was through the cuff door. Only people he had contact with are the nurses who would come in and assist him, give him his medications, whatever else that he needed. But then we heard about how he's looking forward to leaving that situation and going to the Department of Corrections. Now, certainly he's not looking forward to spending the rest of his life in jail. I wouldn't make that argument to you. But he's looking forward to the move. Remember what Dr. Hall said. He has more privileges at the Department of Corrections than he does here. For goodness sakes, he can get musical instruments. He can get his guitar. He's going to have contact with people. It's a better situation for him. I'm not trying to say that this is a good thing and this is something that he wants. But ask yourself, is a move simply from the King County Jail to the Department of Corrections, does that really adequately address what he did in this case? We heard some testimony from Dr. Cunningham, and I think it was Mr. Grunhagen who talked about the future dangerousness. And you knew early on, I believe it was during the cross-examination of Dr. Cunningham, Mr. Baird was conducting it when he pretty much said, you're not suggesting that we're saying that Mr. Monfort's going to be a danger in the future and is going to do this again. I mean, that's never been our argument. But there are a couple things to point out about that. The three of the most important factors, you heard Dr. Cunningham testify, Mr. Grunhagen talked about this as well, regarding someone's potential danger, their ability to commit crime or their likelihood to commit crime, their age, education, and social contacts. Well, how old was Mr. Monfort when he killed Tim? He wasn't 18, he wasn't 17, he was 41 years old. And if you look at those charts, a 41-year-old probably doesn't commit crimes hardly ever. But you know who did? The defendant. Those with a GED are far less likely to commit offenses. Well, what was Mr. Monfort's educational level at the time he killed Tim? He had a bachelor's degree from the University of Washington. And how about social contacts? Mr. Monfort, you heard that he has loving family and friends who care for him and will continue to care for him after he is sentenced. That wasn't any different back on October 31st of 2009. So all I can really say about that, ladies and gentlemen, is I'm not arguing he's going to do anything like this again. But he does appear to be the exception that proves the rule. You heard a lot of reference by counsel to Dr. Schauten's testimony. In fact, I would venture to guess that of all the experts discussed by defense, Dr. Schauten's name came up more than anybody's. And you have to ask yourself, well, why is that? Because, I mean, he was the state's expert. Well, there are two reasons. One is for that reason. If you can take the other side's expert and throw it back and use it in your support, that always looks good. And we get that. But there's a more basic reason. It's because Dr. Schauten was the most credible witness who testified about how this situation could have come about. And you heard a lot of testimony, or a lot of argument, about how Dr. Schauten and Dr. Brahms agreed on a lot of things about Mr. Monfort's development and how he came to where he was. There's one big difference, though. Mr. Luer would talk to you about, whether it's a delusion or an extreme belief. Those are not, different sides of the same coin. Those are very different. Whether Mr. Monfort was delusional, had delusional disorders, Dr. Cunningham testified to, and whether or not Mr. Monfort had become radicalized as a violent extremist, those are two very different things. And remember Dr. Schauten not only is a forensic psychiatrist, but what is his area of specialty? Terrorism. Dr. Schauten explained to you how Mr. Monfort got to this point, just as many others have gotten to that point in their life in his area of expertise. Are they all mentally ill too? He believed what he did was right. Anyone who commits such atrocious acts believes they are right. Otherwise, they wouldn't do it. Does that mean they are mentally ill and not responsible for their behaviors? Counsel says what the state could have called rebuttal, and they didn't call anybody. Well, what are we going to do? Are we going to call somebody here to say that racism doesn't exist and isn't painful and damaging? That bullying doesn't exist or doesn't have lasting effects on people? Or that maternal depression doesn't really exist? Or that Mrs. Monfort wasn't depressed? Of course not. The question for you is whether or not Mr. Monfort's history, all of these things counsel has argued to you as mitigation, is enough. If the state has proven to you beyond a reasonable doubt that the death penalty is appropriate. That's all it is. Mr. Gruenhagen said that, the defendant being sentenced to life in prison would allow him to, and I believe the words he used was, spend the rest of his life doing penance for the terrible things he did. Well, what's interesting about that, ladies and gentlemen, is that's not true in this case. Penance, as you probably are aware, is derived from the word repentance. Someone who's sorry for what they did, seeks forgiveness. Mr. Monfort is not going to suffer from his conscience about the horrible things he did because he has no concern about what he did. He's not going to have to live his life doing penance. He's proud of what he did. And as you heard him tell Dr. Hall, he was concerned that when he went to the Department of Corrections, that he wasn't going to be able to continue to get his message out there. That's not penance. That's continuing on. Mr. Gruenhagen also I believe, said on at least 2 separate occasions, that the death of Tim was merciful. Mercifully, he didn't suffer. Mercifully, it wasn't a prolonged death. Is this what we're talking about when we're looking at mercy in this case? Now, Mr. Gruenhagen also asked you when to consider mental illness as a mitigating circumstance in this case. Take in consideration Mr. Monfort's demeanor in court. And I agree. Take that in consideration. Let's talk about the 2 items of demeanor that are in evidence before you to consider. Remember the videos of Mr. Monfort's speeches that he gave about the Constitution, the Founding Fathers. And at first blush, I'm sure when you saw those, you thought, oh, man, that's a little weird. It's a little crazy. But then remember his phone calls to Dan Keller, critiquing himself, saying, I didn't get to say what I wanted to say. I didn't feel good about it. But I have more to say, and I'll let you know when it's coming next time. There's the one where Judge Kessler is telling him to be quiet, and he just keeps talking, and then we hear the phone call to Dan Keller a couple days later, and the defendant's actually laughing about it. Please, ladies and gentlemen, do take into consideration his demeanor in this courtroom. Finally, I want to talk about some of the more recent testimony that we heard. Dr. Brahms. Mr. Lohr said to you that the state ignores her testimony about Mr. Monfort's regret and sympathy. Well, regret and sympathy are 2 different things. I think we all agree on that. Regret is you feel bad for something you did. Sympathy in this case, is described by Dr. Brahms, is that Mr. Monfort felt bad that Tim's kids had their father taken away by him. Kind of hollow sympathy. He caused it. Regret, however, is nowhere to be found. And if you believe Dr. Brahms that he actually has regret, you have to ask yourself, well, what was it about her talking to him the day before she used to testify in this case that somehow changed his overall perception of what he did? Again, we don't have any notes, so we don't really know what happened during that conversation. But you have to ask yourself, is that really how he feels about this? Does he regret what he did? Of course not. So, ladies and gentlemen, I'm going to stick to my word. I don't have anything else to say other than this. You have a very difficult decision ahead of you. one that I agree with Mr. Lore 100% on, I would never want. But I'm not going to stand here and say that it's one that I relish asking for either. But we are a country of laws, and you have all taken an oath in this case. And as defense counsel repeatedly reminded you, you all agreed you would have an open mind about this decision you're about to make. And I would simply ask you that when you go back and discuss this case, do not ignore the evidence, the facts, the circumstances under which Mr. Monfort committed these atrocious acts. That is the reason we are asking you to sentence Mr. Monfort to death. However, what I will say is, whatever decision you reach, and I said this in my opening as well of this phase, whatever decision you reach, it will be the right one. And you can all rest assured of that. But we are asking you to follow the law, consider the facts, and impose the penalty of death in this case. Thank you all very much.
Members of the jury, all of you can go into the jury room in a few minutes. The three alternates will then need to come out after you've gathered your things. That's jurors 14, 15, and 16, and we'll need to speak with you briefly before you're free to go. Don't begin your deliberations until all 12 of you are alone together. That includes court staff. Court staff does need to move the exhibits back into the jury room, and as you can imagine, that takes some time. So after a few minutes, after things have cleared out, we'll be giving you a break, probably just an early lunch break. And then when you come back, all of the exhibits will be in the jury room, and you will be able to begin your deliberations. Okay, I'll ask you to please retire to the jury room, and the alternates come right out, please. Okay, let me address the gallery and the media. The alternates are not excused. They may not be questioned. They may not be spoken to until a verdict has been announced in open court. So that is a clear court order, even though they will be not deliberating with these jurors. At this point, any other matters that the counsel has for the court?
Only scheduling, Your Honor. I believe during the first phase, the court said any verdict after 2:30 would be taken the next day. Are we sticking to that same?
We probably will have to do that because DAJD has needs a longer period of time to get back here.
Okay, just for scheduling. Thank you.
So what they've said is 2 to 4 hours, which is kind of vaguer than I would prefer, but I don't know I'm not sure what that means. Anything else from lawyers? No. Okay, I'm going to ask that the gallery please clear out from the hallway as soon as possible so that the jurors can leave easily.
We're staying here until the alternates come back.
Yeah, right. And if the public wishes to remain present while I speak with the alternates, that's fine.
Excuse me?
If the public wishes to remain present while I speak with the alternates, that's fine.